Welcome to the Immigration Talk Show brought to you by Sakshi TV. My name is Ranjit. We are here today with the attorney Prashanthi Reddy to discuss the latest updates on immigration, H-1B process, and also Q&A. You can call the numbers displayed on the screen and ask any question related to immigration, and our attorney will be glad to answer. We'll start taking calls in a few minutes. Before starting the show, I would like to repeat the disclaimer. Please note, this show does not provide any legal advice. It is general in nature and it is only for informational purposes. Sakshi TV news and agents are not responsible in any way for your actions. Please use the information at your own risk. Hi Prashanthi garu, how are you?
Hello.
Yeah, before getting into our the regular topic, the H-1B process, I believe we have one update yesterday, regarding the H-4EAD case being withdrawn. Could you please start with that and then we can jump into our topic?
Right. So if you look at the website which has the regulations on it, it clearly shows that it was pending for a long time, a few years actually. The regulation, but it was not actually published. It was just in pending state. But now, after the Biden administration has come in, they have actually withdrawn that regulation to remove the EAD. So what the history is that during Obama's era, there was an executive order passed, and H-4 EAD was granted for some people. Mainly for those whose spouses have an I-140 approved. It's for them. So some are eligible and some are not. So once the Trump government came in, and then a more conservative bloc took over the whole immigration space at the government level, there was a lot of backlash against, granting H-4 EADs. And because there's so much, they're not tied down to one employer, they can work for any employer. So there's a lot of flexibility. So there was a group that filed a lawsuit. And also by that time, the government had also, put in a regulation, but had not yet published it. So they were still going through the OMI and ORI and, going through the process, pre-publication process. But it took a long time. And then a couple of court dates went by, and then the government said that they would publish the regulation. So the what they're asking in the court was moot, because even the government wanted to remove H-4 EAD. So the courts gave them time to publish the regulation, wasn't done. So now we see that the new government has actually withdrawn that pending regulation. So it looks like the new government is not against H-4 EADs, which is great news. So we do still have the court case, but we're hoping that that can be resolved. So as long as if it's not, and if the Biden administration is not against the H-4 EAD, then they will just pass a regulation for it this time. And go through the entire process instead of doing it via an executive order. So I think the whole substance behind the case was that it was done in the form of an executive order, and the government does not have, the right to make changes to immigration law via executive orders, right? So this is what's been happening with the Trump government also. He's issued so many executive orders against immigration, basically. There have been a few that are pro-immigration, but mostly anti-immigration. So let's see what happens in the court case. If the court case is won by that opposing group, then we will lose H-4 EAD regulation. But if it's not, if we're able to prevail on that, then H-4 EAD will stay as is. But it's definitely great news for a start, because now we know that the government is not against H-4 EAD. They are again supporting it. So it makes it much, much, much easier, obviously, to, because they're the opposing party in the court. So, for them to fight it and keep it as it is, maintain the status quo. And this has been like hanging on our heads like a sword for a while now. For a few years, people have been calling and asking me, oh, should I remain on H4EAD? What's happening with the regulation? What's happening with the court case? This is definitely good news. It's going towards, it's definitely positive news. It's going in the right direction.
Thanks, Prashanti. Getting into our topic, today's topic is H1B. So let's start with the basic questions. What is an H1B? And, are there any requirements for H1B? Like who qualifies for H1B?
So H1B is a work visa that is granted to people who work in a specialty occupation. So a specialty occupation is defined as an occupation that requires a bachelor's degree in a specific field, and the beneficiary has to qualify also, which means that the beneficiary has to have that bachelor's degree that is required. For example, a software engineer position, I'm just using the most commonly used title for H1Bs. The software engineer position is a specialty occupation because the requirement is a bachelor's degree in computer science. And the way they look at that requirement is they look at the industry standards. So they look at what is generally required in the industry. So what they often refer to is something called the Occupational Outlook Handbook, which is a handbook that's written by the Department of Labor and it's available online, OOH. And it lists a wide variety of job titles and positions and requirements for those positions. So they usually look at that for reference, but it is not mandatory that they have to look at only that, or it's not that if there is, it mentions something in that and you cannot actually file. So that is not, the OOH is only for reference, but it is not something that has to be looked at by law. So you can look at any other references also if you have something equally good. You can even go to dice.com or Monster or any of these big job search websites, or maybe IT websites where they mention job titles and qualifications, or you can go to university websites where they mention usually how to obtain a job in a certain position. So anything that is suitable is and noteworthy, you can go to that website and check. So it doesn't have to be just OOH, but it's a start. So for example, if it mentions in the OOH that a bachelor's degree in computer science is required for a software engineer, then and if the beneficiary who is seeking the H1 has a bachelor's degree in computer science, and remember when I say bachelor's degree, it has to be a 4-year degree. It cannot be a 3-year degree bachelor's like they have in India, but a bachelor's in engineering is a 4-year degree. If it is a 3-year degree, then they have to have additional work experience, and an evaluation has to be done from an accredited evaluation service, whereby they give the degree to be equivalent of a bachelor's degree. So if you combine 3 years of work experience and maybe a 3-year degree, that will be equivalent to a 4-year degree, because 3 years of work experience is equivalent to 1 year of college. That's how they equate it. So 3 plus 1 is 4, and so that way you can get the equivalent of a bachelor's degree. So there are many issues with reference to qualifications of the candidates as well. So the candidate has to be qualified. The job should be a specialty occupation. Then it's possible to get a H1. So that obviously that's the crux of the matter, whether it's a specialty occupation or not. And most RFEs, requests for further evidence, deal with that matter, with the RFE, with the specialty occupation, whether the position is or it isn't. So oftentimes we have to submit, one way of showing, if you're not able to show, any websites or reference materials to show that it is common in the industry, that's only one way of showing that it's a specialty occupation. Another way of showing that's a specialty occupation is that the job duties itself, maybe the job title is never indicative of whether a position is a specialty occupation or not, because every company has internal job titles which vary. So what they look at is actually the job duties. So you have to be able to show that the job duties are so complex that only a person with a bachelor's degree in a specific field can do that job. So you should be able to prove that via an explanation, via an expert opinion, however you choose to prove it. So that's how usually specialty occupation RFEs are responded to. So that's how you file a H-1B. That's who qualifies at least for a H-1B.
Okay, could you please explain about what the quota of the H-1B? How much is reserved for specifically for India or other countries, or how much is reserved for students with STEM degree who has pursued masters here? And I believe there is also another quota for Singapore and Chile.
So altogether it's 85,000, 20,000 reserved for masters, for people who have a master's degree. It doesn't have to be in STEM, any master's degree. So the thing about the quota is that now obviously we have a limited number of H-1Bs, and the demand far exceeds the availability. So each year in March, that is coming, this March, there will be basically a lottery system. Because, and it's basically first come, earlier it used to be first come, first serve, but it was just, obviously all the cases went out on the same day, on the 31st. And so because April 1st is the actual start date. So March 31st, you have to send out all your cases so that they reach on April 1st. So obviously all those cases that reached on April 1st, if they had more than X number, if they have more than 85,000 cases, then how are they going to decide who to choose and who not to? That's why they had a lottery system, and they said that whatever cases came, it was no longer just receiving cases on the 1st. They kept the cases open until the first week of April. So for example, till April 5th, April 7th, whatever that first week is, and you could send out cases instead of the FedEx and UPS being overwhelmed, or the service centers getting overwhelmed by receiving thousands of packages on the same day. They made it easier on themselves, and they said, whatever packages we get in the first week, we will accept them, and we will then do a random lottery selection via a computerized lottery selection. And the cases that are not selected in the lottery, we will send back. So that's what they did for many years. And people often filed, companies, if they needed 10 employees, they would file 20 so that they get a chance of at least getting 10 or 5. So that's how it used to work. Now, since last year, they've started something called the H-1B registration process. This way, you don't have to file the entire petition. You only have to file online a form with some particulars: the employer's name, beneficiary's name, some basic information, which is filled out online, and everything is automated. And you'll get a receipt. And once it's picked, so from March 1st to March 20th, you can do this. You can file it anytime in those 20 days. And on the 20th or after, between 20th and the 30th, they'll do the lottery. And then they'll again tell you which cases were picked, and that's automated as well. You'll get an email, and you can go onto your portal and check whether your case was picked or not. And then automatic receipt is generated once it's picked. And using that receipt, then you can file your H-1B in 90 days. So that is the process. You have a whole 90 days. It's not just a week within which all the petitions have to be filed. And also another good thing is, after the 90 days, if they see that there's still numbers available, they can have a second pick, a second lottery system. They will not have another registration because they already have enough. Every year they have sufficient cases. This year they had sufficient cases registered, 2 times the amount needed or 3 times. So they will not have another registration, but from the same cases, they will have another lottery pick. So you can expect a few more cases to get picked during that time. That's what happened last year as well. And I think the same thing would happen this year. because a lot of people end up not filing also. So, then you gain some extra after registering. So you gain some extra numbers that way. Earlier, what was happening is all the cases were going, the visa numbers were going waste because, there was no way of having a second pick. So that was great. So that's a good thing, I think, the registration system. But this time what's happening is that there is the Trump administration wanted to introduce a criteria in the lottery system. Instead of making it random, they wanted to hold the lottery in batches, which means they wanted to hold that lottery based on wages. So they would give preference. First pick they would do for level 4 wages, then they would go to level 3, level 2, and so on. So when it came to level 1, it's pretty much, very unlikely that your case will get picked. And if you're a level 4, another interesting thing is if you're a level 4, say, in a small state, Kentucky or somewhere, Idaho or somewhere, and level 4 in California, the wage for California might be more. For example, if you're level 3 in California and level 4 in some other small state, even though the wage in California is more, most probably the one from Kentucky will get picked because that's level 4. So they're just looking at levels and not the actual salary, which again is, they're not even achieving what they want to achieve. So I'm not sure how that is useful. But anyway, we don't know if that will be implemented this year, this cap, or not. We're still waiting for information. It's supposed to be implemented for March 9th as per, the regulation. It's been published, but the 60 days time that has been allotted is the 9th. But we have heard that it will be postponed beyond March 20th again. So we're hoping.
Sorry to interrupt you, Prashanti. We have a caller, Vijaya from California. Let's take the call and then we can resume the discussion. Hi, Vijaya. Welcome to the show. Please ask your question.
Hello. Can I ask now?
Yeah, please go ahead.
So I have a H1 where I have worked like almost 5 years of it. So it was all from 2006 December to 2012 December. So during that time frame, I used 5 years of it. After which I transferred to H4. Now, if I want to go back to H1, if I find an employer, is there a possibility to use that old H1 and do a H1 transfer?
So once you file for a change of status to a H4, you cannot file a transfer again unless you're presently on a H1. So since you're not on a H1, you will be on a H4 at this point. You will have to file a change of status from H4 to H1, but you will not be subject to the cap because you were already counted towards the cap. Of course, if your 5 years is over, you will get only an extension. You'll only get a H1 for 1 year, unless you have a labor or I-140 pending or approved.
Ready to file. I think they will be ready to file, but my only concern is like since the last it was valid was in 2012, right? So I heard somewhere that if there is like too much gap of like 3 years, they cannot use the old H1 for transfer. So I just want to know
So
if
it's
I
not
can
a
use that
transfer.
old H1
It's not a
or
transfer,
no.
but yeah, it's not a transfer. You keep using the word transfer. It's not called a transfer. It's called a change of status because you're changing status from H4 to H1. So I understand the question that you're asking, even though, so just for the audience, basically, I think what you're saying is that you're worried whether you'll be subject to the cap or not. I think that is your question. And if you were on a H1 more than 6 years ago, then you will be subject to cap, which means that you have to file again for the registration and go in the lottery. But if you recently were on a H1 less than 6 years ago, then you're not subject to the cap. You can automatically file for a change of status, even though cap may not be available to you. You can file for a change of status from H4 to H1, as long as you have enough time left and, of course, a job in hand.
Yeah, I hope it answered your question. Yeah, we were talking about, the new H1B rule that's postponed for 60 days.
All right, so we're hoping that that H-1B registration rule will not change, and it's still going to be based on randomized lottery rather than on wage levels, but I guess we have to wait and see. I think the other thing we can that we didn't discuss is the documents needed for filing a H1. I think that's the
that's the one. Before getting into that question, we have another caller, Kalyani. Let's take the call, Prashanti garu. Yeah, hi Kalyani, welcome to the show. Please go ahead and ask your question.
Yes, Prashanti, I have a question. I'm currently on H4 status. So last time when we have applied for the H4, we have got the receipt notice, but however, after getting the approval, we have missed the approval notice. Like it was not being delivered to my home address, and we tried calling the USPS guys, and they have misplaced the courier somewhere. So now again, I have to apply for my H4 extension. So do you think is it going to be a problem as I lost the approval copy, or do I need to provide any kind of explanation? Because as I did not even travel out of the country, I don't even have stamps.
So if you didn't get the approval, then why didn't you pursue it with the USCIS? So get a duplicate approval. What's the problem in getting the approval? If you miss the law,
okay.
then get a second one.
I mean, how do I apply for the duplicate copy?
You have to file the appropriate form for that. There is a form. I-824, I believe.
Individually? Can I do it individually, or do I need to hire any attorney, or how it is?
You can do it on your own, but I think if it's a H1, are you looking for the H1 approval or H4 approval?
No, H4. I'm on H4.
You can do it, you can do it without your employer. You can do it on your own or through an attorney, however you want to do it.
Any idea about what would be the processing time, like how many days we can expect the copy?
Right now, no, I don't know. It could take a few months because everything is delayed.
Without that copy, can I go ahead and because when I checked the case status, I could see the approval approved. The case was approved, right? So normally
when was it approved?
The same. Okay.
When? I'm asking you a question. When was it approved?
Yeah, it approved a month back.
Okay, so maybe the approval will come. It must have been missed in the mail. Just don't bother with filing the duplicate. Just call them and ask them to tell them you didn't receive it. Did you change your address?
No, we didn't change the address. They clearly gave us the tracking details, and it was actually misplaced by the courier people, the mail guys.
Okay, so then ask them to send another.
Working on them.
Yeah, ask them to send another approval. If all else fails, file for a duplicate approval. But right now, since it's just been a month, I think you can still ask them to send another approval. You can just do a service request, or talk to Emma. Emma is quite helpful. Or file a duplicate. But at this point, I don't think you need to file a duplicate. Just, I think, ask for another copy. They usually send it as a courtesy.
Okay, sure. Yeah. That was my concern. Thank you.
So what are all the documents that are required to file an H-1B?
Right. So we discussed as to who can file a H-1B. Now that we know who can file, we have to submit evidentiary proof that that person qualifies to file. So in addition to, and also, of course, the person has to be in status. The person has to have a passport. So in addition to documents showing status, and for example, when I mean status, it could be depending on the status that you're in, different documents might be needed. In general, I-94 is required. An I-797, which is an approval, might be required. Your passport is required, a valid passport. And if you are on H-1B and you're filing an extension or a transfer, pay stubs are required, or W-2s. Your last 3 pay stubs to show that you're presently working. If you're not working, and if you have an I-94, that does not show status, because in order to be in H-1B status, you have to be on the payroll. So those are status documents that you need to submit. In addition to that, we talked about who qualifies. So a person with a bachelor's degree in that specific field, required field. So if it's a software engineer, then we need to show your bachelor's degree. And we talked about the 3-year bachelor's degree and what documents are needed. If it's a 3-year bachelor's degree, you need the evaluation. You need the experience letters. As I said, that 3 years of experience is equivalent to 1 year of degree. So when you're doing the evaluation, you will have to submit the experience letters to the evaluator and also to USCIS. And the experience letters have to follow a certain criteria. It has to have the start date, the end date, the job title, job duties, detailed job duties, and it has to show progressive experience. So
hi, Prashant. Sorry to interrupt. We have a caller, Revant. Let's take the call and then we can resume the discussion. Hi, Revant. Welcome to the show. Please go ahead and ask your question. You are on the air.
Hey, hi. This call is regarding my wife. My wife had an H1 and that got expired on December 31st, 2020, but her I-94 was valid till January 10th. And unfortunately, she lost the project in the last weeks of November. And the current, the H1, the petitioner gave her December as a vacation. So we filed her H4 in December last week, but she got the project on January 7th, and the new employer has filed a H1. So I have a question: what happens if the current H1B gets denied? Because we have applied for a H4 online on December, 26th or 7th.
So is it the same employer that filed the H1 now or different employer?
No, different employer, ma'am.
Okay, so then simply withdraw the H4 or keep the H4 as is, file H1 in premium processing, right? And then if the H1 gets approved, which it will get approved much faster than H4 anyway, then you can withdraw your H4. So as per the last action rule, whatever you file last, that is what counts.
Okay, because my question is when she has the project, so she started working on the receipt.
She cannot.
So she cannot work on the receipt?
No, because you're filing a change of status, right? You're filing filing her H1 based on her pending H4 receipt, correct?
No, while filing the H1B, we have used the earlier H1B because she had 10 days grace on her I-94 because the H1B expired on December 31st and she has 10 days I-94 valid.
Okay, so did you file before the I-94 expired?
Yes, we have filed it on Friday, which is on 7th or 8th of January.
So you filed the H1 first and then filed the H4?
No, we filed H4 in December, but the start date, what I have mentioned on the H4, it was asking the start date, we mentioned on January 11th, because till January 10th, she had a I-94 valid on H1.
So what is your question now? What is your question?
Because we have done a H1B extension with the new employer, and my
Not
question is the H4 was also applied.
Yeah, so again, I'm telling you the law. Last action rule. Whatever case you filed last, it's not about the start date. Whatever case you filed last, that is the status that you're going to be in. So you need to withdraw your H4 if you don't want her to be on H4 and continue with the H1. Do the H1 premium processing. Same, my answer doesn't change. Do the H1 premium processing. The H1 will come much before the H4 anyway because H4 there's biometrics, it's taking 6 months. So do the H1 premium processing. Once the approval comes, just withdraw the H4.
Ma'am, what if the H1B gets denied? I should still apply.
Then you have the H4. Then you have the H4.
Oh, I have the H4. That should be working, right? I don't need to apply the new H4 again.
No.
Okay, fine.
The last action rule comes into place only upon approval.
Okay, fine. Thank you.
Comes into play only upon approval. Yeah.
Okay, fine. No problem. Thank you.
You're welcome.
Okay, going back to our discussion, we were talking about the documents needed for the H1B.
Right. So as I was saying, you have to submit, I think we are talking about experience letters.
Yes.
So we have to submit experience letters, and in some instances, and they have to be a certain way, and as I was discussing what the content of the experience letters have to be. And sometimes it may not be possible to get experience letters because the company is closed, or you have no contact with the employer, whatever it is. In that instance, you should get whatever evidence you can from the employer. And in addition to that, get affidavits from co-workers. The affidavits are not always accepted, but affidavits have to be on stamp paper if they are from India, or they have to be notarized here by a notary public. So, that's an alternative form of evidence if you don't have the detailed experience letters. In addition to your degree copies, all your transcripts, experience letters, you also have to submit, obviously, the I-129 forms. You also have to submit something that is called an LCA. So the first step would be to file an LCA with the Labor Department, the Labor Condition Application. The LCA denotes the wage, the work location, and the job title. That's the information that's on an LCA. So all that information is first approved by the Labor Department, and the wage level is approved by Labor Department. Once you get the approval, which takes about 5 to 7 business days. So it's kind of a two-step process. First, you get the LCA approval, and then you file the package with the I-129 forms with USCIS. And you have to send it to the right address, and it depends on the work location, really. And now actually it depends on the company location. So you have to look online as to what the address is. If you send it to the wrong address, your case will get rejected. And if you're falling out of status, then even if you send it on time, they will not consider it to be a valid application. And once you resend it, if your I-94 is already expired, then you're out of luck. So make sure you send it to the right address the first time. So those are the documents. I think I covered everything. Pay stubs. If the person is on F1, status documents, you'll have to submit all his recent I-20s and a letter from the school saying that he's completed all his degree requirements if you don't have a copy of the degree as yet. I think that's about it for the F1s. Everything else, the I-94 is and the I-797 approval is what counts as status documents. So those are the documents that you have to submit. In addition to that, you might have to submit some company documents, depending on the type of work that you do, the company that you're working for. In general, you have to show, in addition to whether the job is a specialty occupation job or not, you have to show that the employer has a specialty occupation job. And he's not filing a frivolous application even though he doesn't have a job. So you have to show that he has a job, and you have to show that it is a specialty occupation job. So how do you show that? It's not just putting a job title in there and saying, okay, since this job title is a specialty occupation, it's automatically, I qualify. So the employer has to show that he has a job for a software engineer. Now, if you're going to be working as at a third party, like if you're working for a consulting company, for example, and they're going to place you at a third party site, or they're placing you in their office, but you're working on a project, then they have to show, the end client letter. They have to show purchase orders, contracts. The employer has to. That is how the employer shows that he has a valid bona fide job for the beneficiary. Usually, they're asking for these things. They've been asking for quite some time now. Though there's a controversy as to whether they should ask or not, but yes, they've been asking about the validity of the job offer. So that's additional documents that you may need to show. Also, you have to show that the employer is a bona fide employer. So sometimes they ask for documents from the employer, such as their registration documents, their office lease documents. They're operating out of home, and they submit their residential lease, and they say that I'm running my office out of my home, then your case is not likely to be approved. So make sure your employer has a proper commercial space and has a proper office. They might ask for tax returns sometimes. So these are the additional documents that you might want to include along with, and then your brochure, the employer's brochure, employer's website documentation, marketing material. So these are some of the documents that you might want to include in addition to the standard documents of, pay stubs and degree copies, status documents, etc.
Got it. So, what are the timelines for the H-1B? How soon an H-1B can be filed for a person? Let's say after now the process has changed. It's a registration. So USCIS does USCIS give some time to file an H-1B now, like stipulated time, and how soon an employer can file an H-1B and what they have to keep in mind so they file on time.
So if it's a cap case, if we're only talking about cap cases, registration is only we're only talking about cap cases then. For a cap case, as per this new registration process, they have to be done with the registration by March 20th. That's your deadline, folks. So before March 20th, you have to register your candidate. And then once you get picked, you have to file in 90 days. So you have to put that in your calendar that you have to file in 90 days. If you file after 90 days, it will not be accepted. Also, one important thing is the start date for cap cases. You have to put a start date of October 1st because that's when the fiscal year is starting, new fiscal year. And you're allowed to file 6 months in advance. So you cannot ask for a start date before October 1st because there is no cap. There's no H-1B quota before that. So you're filing in advance and you're asking for a start date of October 1st. Now, another word of caution to employers or beneficiaries, whoever is interested in the process, is last year, because there were two lotteries. For the lottery, cases that were picked later on.
Sorry to interrupt you, Prashanti Garu. We have a caller, Suresh from Dallas. Let's take the call and we can resume the discussion. Hi, Suresh. Welcome to the show. You're on the air. Please go ahead and ask your question.
Hello, President. This is Suresh. Currently, I am in H1. I have a question, in terms of the secondary income. I was some of my friends who are currently doing buying these stocks, or someone is having a rental property, or someone is doing life insurances. So, my question is, when we are on H1, are we legally allowed to do any kind of these activities? Could you please explain? Is there any?
So that's a good question because that's a good question because that's commonly asked and a lot of people have the same doubt. So you cannot work for anybody or for yourself also on a H1. You have to work only for your employer. So if you want to do a second job, then you have to file a concurrent H1, a second H1, parallel H1. And then you can do two jobs. But without a H1, you cannot work. It's not like an EAD where you have a lot of flexibility. You can want to take up one job, take up another job. H1B is very specific status where, as I was explaining earlier, it has to be a specialty occupation position. So you're not authorized to work otherwise unless it's a specialty occupation position and you filed a H1 and it got approved. So you can, for example, do passive investments. So you can invest in the stock market. But if you're doing the investment like a day trader, and if that's your job, then you have to file a H1 if it qualifies for a H1. You cannot do that as a job. Now you can invest in someone's company or be a passive investor where you're just investing money. But you cannot actually work for that employer. You cannot be managing partner for that employer. So be very careful. Also, real estate or whatever it might be, you can't do a real estate job. Rental property, if that is not your day job, if you don't have 100 apartments and you're renting them out as a business, and that takes up all you. That's a job by itself. Either you're hiring someone to do it or you're doing it yourself. Doesn't matter. That is not allowed. But yes, you can have an apartment and rent it out. So that's like an investment. So you're allowed to do that. It depends on the scope of things, really.
Oh, okay. Okay. So, like a stock market, so as you said, day traders are not allowed. So, at least I can buy stocks and maybe like, let's assume I buy some stock today and I can sell tomorrow or today. So, like, how will be USIS or how they will track? So, that is where because most of the people are doing, so I'm little hesitant. So, that's where I was.
No, just use your common sense. If it is a job that is requiring, like if that whatever trading you're doing is requiring your entire day to do it, or a good chunk of time, then that is obviously a job. You're doing day trading.
Okay.
And you obviously are going to show that is going to come up in your tax return. Of course, they can see it because sometimes it might be more than the salary that you're getting. Then it's going to look suspicious as to whether are you doing your job or are you doing that? What are you doing? So don't let it get to that extent of a huge amount of money coming into your tax return. Then they're going to question it as to where did this money come from? So just be careful, be cautious.
Yeah.
Or on the side of caution.
Thanks for the suggestion. Yeah. Okay. Thank you.
Yeah, that was a good question. Adding to that question, I know a lot of people who have just invested in stocks like 4 or 5 years ago, let's say, especially good stocks like Tesla, they've become millionaires now. So, coming to again, they
but they're not day trading. It's fine. I understand. I did say that other point about sometimes your income from trading becomes more. But, for example, if you put it in one stock or you have someone else managing your portfolio, so then it's not a day job.
Yeah, day trading, as you said.
I know what you're saying. Sometimes why that? You can just have bought property and that property went up, twofold or threefold, and you get $500,000.
Yep.
After 5 years.
That's what it makes sense, as you said, as long as it's common sense that you're not spending more time.
Passive investment.
Yeah, as long as you're not spending actual time on that and you're just doing good investments as a part of, having an investment, then that's probably fine.
You're allowed to buy houses or, speculate.
We were talking about we were talking about, I think, the H1 and what documents are required. Yes.
And the cap, we spoke about a lot of things. So I don't remember exactly.
So the other topic, we only have for the caps, especially for the cap, they have 90 days, and the employer should make sure they have everything on time.
When to file? Correct.
Yes. And what about for the non-cap cases, in the sense, the extensions and all? How soon an H1B can be filed by an employer? I know there is a requirement of LCA, public access file, whatever. They have to do recruitment, whatever. So what's the best?
Right. So an LCA takes 7 days to get approved, 5 to 7 days. So you really can't file before that. So the fastest you can file, unless you have an already approved LCA, the employer already has an LCA which he has not used. Maybe he has taken an LCA and not used it, or he's used it but now is no longer using it. Then you can file immediately if you have all the documentation in place. But generally the delay is because of the LCA, and that takes about 5 to 7 business days to get approved.
Okay, what are the common types of RFEs that receive, and what are the common types of things that employers and beneficiaries should remember and make sure that to avoid the RFEs?
So one main, I think, important thing is that you have to make sure that you qualify for a H1B. So when we file the H1, we look at first basic qualification criteria. What is the job? Does the job qualify for a specialty occupation? Then we look at, does the beneficiary qualify for the occupation? Is his duties complex enough that a bachelor's degree is required? Then we look at the degree. Does he have a degree that qualifies him? Then we look at his status. Is he presently in status? Is he even able to file this H1? So all the questions, also the RFEs, come up on the same basis. For example, if you're filing an F1 to H1, a common RFE is if the person especially is living in a different area and going to school in a different area and working on CPT. A very common question is, how are you commuting? How are you in Texas and going to school in New York? How are you commuting to school? How come you're working here and going to school there? So that's very, very often we get RFEs on that, asking that, making sure that they're valid F1, they're in a valid F1 status and they're taking in-person classes. Now, because of COVID, everything has changed and online classes are acceptable to the USCIS. But earlier, there were only two subjects that you could take online. The rest of the subjects had to be in person. So they often ask questions about how you're attending school. And oftentimes, then we submit documentation showing how the person is commuting. So the classes maybe only are on Friday, Saturday, Sunday. And so he's, then you have to submit airfare receipts or hotel receipts to show where they stayed. Letters from the university showing that they attended in-person classes, copies of their assignments, the syllabus showing that the classes are, how many classes are online, how many classes are in person. So that's one of the RFEs that can come up for a person who is a change of status from an F to a H. There are many, but I'm just focusing right now on the F1. The other RFE that can come up for a student is, again, if they're on CPT, whether CPT was an essential and integral part of the curriculum. And that's a very common RFE that we get. So they want to make sure that the courses that they took are related to the job that he's now doing. And they want to see how it's related and why CPT is required, why curricular practical training is required to learn that particular subject, and why without that practical training, his education would then be incomplete, right? So that's what they want to see on a CPT, because, oftentimes students, everybody's using the system in such a way that they're getting on an F1 in order to be able to do a job, not the other way around. So I guess to avoid, they're questioning those type of situations. So that's another common RFE for the CPT. Another common RFE for students is they want to make sure that if they're on STEM OPT or OPT, that they actually worked during the time that they were supposed to work. If they were on OPT, then they should have at least had voluntary work. If they were in STEM OPT, then they have to show actual paid work. So they want to get letters, they want pay stubs from the employers showing that they actually worked. And there's some certain number of days, 90 days they have to work. They can take vacation, unpaid, or not work. So they want to make sure that the rest of the time they work. So that's another common RFE as well for students. So they could be, so this is for students. Now, there could be an RFE for a person who filed.
Prashanti, sorry for the interruption. We have a caller. Let's take the call and then we can continue. Hello. Welcome to the show. Please go ahead and ask your question.
Hello.
Yes, please go ahead.
Yeah. Hi, Prashanti. Good evening.
Hi.
And my question is, what are the documents required and what is the process to apply concurrent H1 by the employer, the second H1B?
So the documents required are exactly the same as documents required for H1. There's no difference in the documents. It's like filing a H1. Only thing is, when you're filling out the form, we have to mark it clearly as concurrent. That's the only difference, but the requirements are exactly the same. The only thing is that, for example, if you're working on a job already for 40 hours, The number of hours, just be careful because it can't be more than 40. How can you work more than 80 hours a week, right? It has to be something that's believable. So just be careful with the number of hours. You can have 2 full-time jobs, or you can have the full-time job that you had and then the concurrent job could be part-time. So just make sure that your number of hours makes sense.
Okay, hope that answered the question. So yeah, going back to our discussion, we're talking about, different kinds of issues.
Right. So with the RFEs, right? The different issues with the RFEs. So again, depending on what your status was previously, there might be questions related to that. And I don't want to get into everything, but going from an F1, maybe next week, we can go into the other ones. But for now, let's just talk about F1 and B1 since we don't have that much time. The visitor's visa, if you're on a visitor's visa and you're filing a change of status to a H1, then obviously they want to make sure that you are in status. So they would require then in that instance, the main documentation they require is, the I-94, proof that you are in status. And also, if they find out that you worked or you didn't maintain your status or you did something that you were not supposed to do, or, this is valid for any case, I guess, or there's a criminal case against you, they do a background check. All this can lead to, again, an RFE asking for more documents. So it really depends on the type of status that we're in. And then going on to other kinds of RFEs. For example, if you are filing for H1 extension, it could be, they could ask an RFE is making sure that you maintained your status while you were on the previous H1B period. So they can ask for all your pay stubs, your W-2s, your project information, that you maintained status in the last 3 years and you worked in a specialty occupation in the last 3 years and you worked as per your approved LCA. So that is also quite a common RFE on H1s. Another thing that they could ask is also with reference to wage levels. Now, H1B has 4 wage levels, so you could use any of the wage levels. But usually, if you use a wage level 1, there is a particular RFE that you get for that. And that's recent, like the last few years, they've been sending out that RFE for wage level 1. And they're saying if it's wage level 1, it's not a specialty occupation because it doesn't require that level of complexity. So we've been able to overcome that, but and by showing them that they're wrong, that there's no such regulation that if you use a level 1, it's not a specialty occupation. Specialty occupation is a specialty occupation based on not the wage level, but based on the duties. So if we're able to show you that the duties are that of a specialty occupation, it really doesn't matter which wage level you use within that job. So even entry level should be a specialty occupation. So that's been our argument, and we've been able to overcome those wage level RFEs. But note of caution: try to avoid level 1 wages if you can. There are also a lot of other RFEs that. Do we have time?
We are almost towards the end of the show, actually. We can continue in the next session. Before ending the show, I would like to repeat the disclaimer. Please note this show does not provide any legal advice. It is general in nature and it is only for informational purposes. Sakshi TV news and agents are not responsible for any actions. Please use the information at your own risk. If you would like to reach the attorney Prashanthi for a private consultation, please reach at 212-354-1010 or prashanthi@reddyesq.com. Thanks for all the calls and watching the show. It was a great session with interesting topics. And please call in every Wednesday at 5:30 p.m. EST to watch the Immigration Talk Show. Again, it's every Wednesday, 5:30 p.m. EST on Sakshi TV. This is Ranjit signing off. Thanks, Prashanthi.
Thank you.